family cases, our courts focus on therapeutic justice, which is about getting parties to establish common ground and move on with their lives. The changes we have made over the years to the family justice system reflects this approach, this philosophy. As Ms. Hani So referred, a major review was done in 2013, which resulted in, amongst other things, the establishment of the FJCs, Family Justice Courts, specialized family justice courts with specialized judges with its own head of the FJC. Measures were introduced in divorce cases to help these cases proceed more smoothly and reduce the animosity as much as possible. And the focus was also on seeking to protect children's welfare. One very important measure is a simplified divorce track. For those on this track, it saves a lot of time. Parties don't need to attend court. Divorce proceedings are concluded within a much shorter time frame. And it's available to all parties who agree on the divorce and ancillary matters at the outset. And you can imagine it helps to reduce acrimony. It's an incentive for parties to come to an agreement on the issues. They'll spend less time in court. If you take the past year, there were a total of about 6,220 divorce cases. Of that, more than 4,000, to be precise, 4,150 or 66% of divorce cases actually went on this simplified track. And almost half of these cases involved children. Now, you can imagine if these 4,000 cases were handled as the normal litigation process, the amount of time, the money, the acrimony, the impact on the children. So all of that has been considerably reduced. So this is a significant number of couples, 4,000 over couples, their children, who we hope were better able to move on with their lives with as little acrimony as possible. And of those cases that go on the simplified track, the 4,150, 94% were resolved within 6 months. So it's much quicker, much less costly. The Family Justice Reform Act introduced a new maintenance enforcement process, MEP, which would help to address these issues. Under the MEP, there is a new unit called officers, Maintenance Enforcement Officers, or MEOs. They will be established under MINLAW. The MEOs will be empowered to obtain information about the parties' financial circumstances directly from the parties or from third parties, such as banks and government agencies. That will relieve applicants from having to go around, instruct lawyers to apply to court to get the information. That takes time, effort, cost, and usually it is also non-compliance. So when the respondent is non-cooperative, it can go on and on and on for months, sometimes years. But the MEOs will be empowered. People have to answer them. The information hopefully should be obtained faster. So with more accurate, clear information, the MEO and the courts will be better able to distinguish between respondents who cannot pay and respondents who refuse to pay. For those who refuse to pay, the system, the MEP, strengthens the deterrence against them.